of Managing IP Challenges and Regulations, moderated by Ms. Lina Al-Hashmi, the Assistant Manager at Abu Dhabi Department of Economic Development, and participating delegates starting with Mr. Khalid Elkhabir, the Head of Patent Department and Business Development Manager in MENA, Dennemeyer and Associate, Dubai. Mr. Marcus Lee, the Director of Projects and Program, Hello Tomorrow, Singapore. Mr. Ahmad Saleh, the Partner, Head of Patents and Design, R&D Innovation and Co, Head of Innovation, Technology and Entrepreneurship at Tamimi Co. Mr. Faisal Abdullah AlHamoudi, an IP expert. Mr. Richard Gaugeler, a legal consultant at Cedar White Bradley. Mr. Rami Filfil, a senior legal consultant and patent and trademark agent at Rouse and Co International. Mr. Jamie Levy, the General Counsel in Abu Dhabi Investment Office.
Ladies and gentlemen, inventors and investors, dear colleagues and friends, welcome to TIP Summit 2020. My name is Lina Al-Hashmi. I'm leading the Patent Support Program at the Department of Economic Development, and I'll be your guide for this panel discussion. The goal for the next hour is to discuss the challenges and benefits of IP. We will also highlight the existing regulations and formulate possible solutions to improve IP protection. Thank you, Mariam, for introducing our panelists. So all of you have the mic? No? Okay. I would like to know first from the audience, how many of you have registered an IP protection, like a patent, trademark? Just raise your hand. None? 2? 3? Oh, okay. And Miriam, 4. Okay. Only a few years ago, we started talking about intellectual property. How important is this, Faisal?
First of all, I would like to thank you for bringing us to this amazing platform. The questions is why IP is important to us. First, the IP is referring to the creation of the mind. And it could be inventions, it could be literacies, logo, name, different thing. And it is important because it will protect the creator, and he could utilize his creations to commercial it or to use it for a good reason. And why it is important, I believe there are 3 main points. The first thing is IP is important. The first thing is development of the world and the well-being of humanitarians is linked with the innovations and creations. The second thing, if this IP it is important because it will give the protections to the government, to the private sector, to invest more in the area of research and development, and they will produce more creation and invention around it. Creating more innovations will help in creating a future industry, and the creating of future industry will create job. It will create, it will develop and improve the economy. It will improve the quality of the life of the people.
Thank you, Faisal. Marcus, I would like to know your opinion in this topic.
So I guess because I'm the only non-IP lawyer here, but I do have a very good working knowledge because I work in venture capital in Slate. I think it's a much simpler idea for me. It's when we're talking about IP, it is the right for someone to monetize and the right for someone to have the benefit of the intellectual property or the property of the creativity invention that they created. So in doing so, we really protect their interests, and by doing so, we help, as my colleague has said, create opportunities for people to increase the economy, and also not only just in technology, but in arts, for example. we give the opportunity for artists to benefit from their creations. I think in doing so, we create a much better world.
Thank you. I have a question for Khalid. What rights does the intellectual property owner have?
Thank you very much, Lina, for the question. Really, intellectual property, as a general talk, it gives like exclusivity right. This is a general talk. And it's a property similar to any other property. This is intangible, similar to any other tangible, like your car, your house. This you have this your property. If you have intellectual property, it's also you have a full right to use it, to do whatever to do with your right, to license, to sell it, and to import it, and to allow who will import, who will export. So it will give you full rights to exercise your property.
Thank you, Khalid. Richard, can you just explain what the type of intellectual property and what we can protect, please?
When you ask that question, you're saying the different types of intellectual property available.
Yes.
Well, generally you look at your four main types of intellectual property, which would be your patents, designs, trademarks, and your copyrights. There are other aspects of intellectual property rights which maybe won't be registrable, things like trade secrets, know-how, confidential information within an organization. But that would be something that's different. If we're speaking about registrable rights, such as a patent, design, trademarks, anything like that, this is the written form or embodiment of your innovation, of your idea, that you've conceived somewhere, somehow, that is going to either be monetized in some way, commercialized in another way. But before you can actually get to that end point where you can monetize and commercialize or even use it to develop something further, you need to protect it first. And then that's where the lawyers will come in, and that's where we get involved. We need to take that concept, and we have to take that intangible object, and we need to turn it into something that we can identify with words, drawings, pictures, diagrams, anything like that. We then file that, register it, and then you pass on to what you were saying earlier about now you own this knowledge, and you can decide who can use it, who can't use it, who can benefit from it, how you want to license it out, how it's going to be used. But until you've registered it and you get that right, it's free for anyone, and you have no control over your intellectual fruits.
Thank you, Richard. Ahmed, based on what Richard just mentioned, the types and different types of IP, what's the biggest challenges that you're facing as an IP attorney in registering these IP protections?
Okay, thank you. Thank you very much, Lina. Thank you again for Takamul. Thank you for the DED. Thanks for the attendees, and we're very honored to be here today. For intellectual property, Richard, I couldn't put the words better than how Richard arranged the words together and described what patents are. And Richard spoke about four types of intellectual property rights as main types of intellectual property rights, including patents, the way Richard has described them. And I would add to that industrial designs, which are very important as well. Industrial designs, if patents are there to protect the technicalities or the technical solutions to technical problems, devices, systems, machines, and so on, industrial designs are there to protect the ornamental features or external visual features of these objects. An object and a novel and a table, for example, a chair, a car, any object with some kind of novel visual features are protectable under industrial design. So this is the right vehicle to protect the visual features of articles, of objects. So it's a very important category as well. And normally in one object, you can have different types of intellectual property rights that can overlap, including, for example, a vehicle, the Evoque Range Rover. I'm sure that it has some kind of innovation, some kind of patents within the functionalities inside it, as navigation systems or cruise controls or new devices or functionalities within it which are patented. And as well, the shape of the Evoque is protected under industrial design. And so this is something, a type of right which is extremely important. Adding to this, a third type of intellectual property is copyright, which is very, very important. And copyright is there to protect different types of work, including at the top, we start by the literal work. You're a writer, you're at university, you're writing an article, you're writing a book, you have a presentation. This is something which is protected under copyright. As author of this right, you have the copyright, or your employer, if the university is, might have the ownership of that right. So copyright is there to protect literal work, musical work, cinematographic work, and a very important product today, which is software. So the code, which is coded inside a software, this is protected. This is normally protected under copyright. It's because it's the literal expression of the codes. So if someone takes it or reproduce it or and take this source code, this is a copyright infringement. This is a very, very important right today, and copyright also can overlap with other rights in the same article. And a fourth right I'll talk quickly about it is trademarks. So when you open a business and you have your brand, you have the name of your product or the name of the company which you're using as a brand to sell your services or products and get it known through that brand, this is protectable through trademark. It's a very important protection as well. Apple brand today worth billions and billions of dollars. So the name taken alone or the brand taken alone. And we're not talking here about any tangible equipments or technologies or innovations. We're just speaking about the brand in itself. If Apple gives you the right to use that brand, Apple, to put it on your products or services, this is worth a lot of money. So this is basically a very wide overview of these rights. Now, coming back to the challenges, what inventors face today as challenges or on the protection of rights. Now, obviously, in order, and let me put things in the frame of, if you want, on inventions here or patents, right? So if we talk about inventors, of course, one of the very important thing that is important for universities, because we are here in the frame of universities and students and professors, is publication. And I think one of my colleagues here has discussed about in a previous session or about the criteria or conditions of patentability. One of them, most important, is novelty. And it's extremely important for inventors who come up with inventions to keep it confidential until some formality requirements are completed, which is the preparation and filing of a patent application, as Richard said. So this is extremely important to have. And one of the challenges sometimes universities and inventors face is that they publish or they disclose their invention before they come and they protect it. So this is something extremely important to be aware about. Now there are of course other types of challenges with respect to the types of the inventions, like computer implemented inventions today, or softwares, or artificial intelligence, or blockchain technologies. There are legal challenges, and it depends on the countries, and we can for sure dive into that if you want. But let me give the opportunity to my colleagues to give their opinions on that aspect.
Yeah, I'd like to know Rami's opinion in this topic.
Yeah, so thank you very much for having us here and for Takamul and DAD for arranging for this. I believe actually that one of the points I wanted to talk about and to complement what Ahmed has said is the toughest challenge that we actually find as IP attorneys and patent attorneys is the lack of IP awareness. So at the university scale, as Ahmed said actually, so that the mentality is for the professors, I want to publish. For the students, I want to assist in the publication so that my name goes in there. But that's really what is crystallized in their mentality. A lot of what we find is, and that's actually one of the things that we as IP attorneys are trying to do, is to increase that IP awareness, right? So there is a scenario where you can actually have your cake and eat it. So, rather than actually try to beat everyone to publish or to, talk in a conference or something like that, then you can definitely, work with the attorney in order to actually get some kind of protection along the lines of what Richard has actually said. So, prepare a document, file it with the patent office, and then go and talk about it. Like, it doesn't have to be a year or two, and then you'll lose your position in that track. So that's one of the things that I believe is essential. How do we deal with it? Of course, there's the talking to the different entities, but I believe it has to be more fundamental than that. There are courses about IP in the universities, but it has to actually be more than that. I truly believe that. I can take a course as an elective or I can take it as a mandatory. But then as the panel before us, the mentality of the students at universities, I just want to cram a few days before the exam and so I can actually ace it and then forget all about it, right? It has to be more. It has to be something that you get to actually engage. You see the benefit of it, right? Maybe it doesn't have to be called an IP course or an IP class. Something along the lines of even learning history. Right? So, you can see how the people who actually, how they actually come up with the invention, how they monetize it, how they can actually make something out of it, make it a success story and teach it to the students. And I believe that actually would be something that would generate the most benefit, right? So that's on the innovator side, right? Obviously, there is challenges that comes on the other side. So, on the patent office side, for example. Right? Some of the things that we actually see as patent attorneys is there's a disconnect between the government entities, right? So the patent office will, for example, require specific formalities to be filed for even the application to be examined. Yet one of those entities would not even, which are the only entities that can actually sign it, such as a notary public, would not give you that document. And I'm sure you're actually seeing it in firsthand, where multiple applications have been filed and lapsed because that formality has not been met. So adding to that IP awareness, not only in universities, but also in government entities, so that everybody can actually understand how the process works, what's their role in it, and how they can actually achieve that role in order to make the machine run.
Thank you, Rami. Faisal, do you want to add anything regarding these challenges?
I believe the first questions need to be asked, why the creator he need to protect or register his IP, and this is a key question before he enter in the registration system. He need to understand, do I need to protect my IP or not? If I protect my IP, what type of protection I need to enter? What type of business model I will enter? Because IP is intangible asset, it is a business. He need to understand it will cost him money and effort to protect the IP, and he need to understand where his business will be implemented. So this is very important because there will be, because IP is territorium, and he need to understand where his business will be implemented. The second aspect I see, it is very important to understand the registration system, because IP, it is a system, and there are multiple stakeholders. The creator or the investor, he need to engage with them. One of them is IP attorney. IP attorney will help him in drafting his creation or his inventions. Second thing, he need to engage with the IP office. The third, he need to engage with the notary or legalization system. And different countries have different system. And this will require a lot of effort from the university or from the industry or from the individual inventors. And it will cost money. And if he don't have the first thing, if he don't have the strategy, he will lose the registrations and the business of the IP.
Yes, please.
Might add something to that as well. So from the Abu Dhabi Investment Office perspective, we would like to see and we want to invest in and are investing in high technology-based opportunities to assist the government and the economy transform into a knowledge-based economy as one of the key goals of the Emirate of Abu Dhabi. In doing so, we look at a lot of applicants that come through to access funding. And it's true and it resonates with us that every company, be it an ag tech company, be it an OEM, a defense company from the US, or be it a manufacturing company here, is a tech company. They all pride themselves on a competitive advantage that they have. And when you drill into the competitive advantage, a lot of the time it comes back to something unique that they do that provides that competitive advantage, which allows them to be a leader in the market that they're in. What we're very keen to do as Abu Dhabi Investment Office is support both the R&D side of providing safe ground, capital and a landscape for inventors, startups and R&D centres to focus on key areas where Abu Dhabi has a natural competitive advantage. The IP framework is very important for those people, particularly coming from overseas, to understand that they have a certainty in relation to how the intellectual property that they create will be protected and commercialised within the jurisdiction. And we have a lot to be proud of, I think, about the current landscape of the intellectual property scenario here. But having said that, there's still challenges. When you attract people coming from overseas, particularly large US companies looking to commercialise or invest, a key part of what they want to understand is how will my IP be protected? And I think it's actually something we need to look at broadly. It's not simply a view of a very specialist view of intellectual property. When you talk to them or talk to startups, a lot of it's about confidentiality. When should I actually disclose? And we've all touched, I think, on university publications and the natural tension between publication and inventing. But there's a requirement of people to understand what their actual intellectual property rights are. And you ask that very simple question. It's a very simple question, but people get it wrong a lot. You know, just have an interview with Flash and Bon Jovi and talk about who owns the IP to the songs, and you'll see there's a significant debate and a long court history around who owns the rights to this intellectual property. Understanding that's fundamental. I'll leave you with one point as I share the microphone as well. Part of what we're doing in commercialising and transforming an economy and building value in companies through intellectual property also involves them being able to defend their intellectual property in an acquisition process, a merger process, or a big commercialization process. Every startup I meet really has one goal. We want to sell as much as what we have to as many people in the world as fast as possible, scale from Abu Dhabi and go global. It's a great story, okay? But when you need to onboard capital, venture capitalists and the people that were on the panel beforehand will tell you, we need to understand what your asset is. How do you prove you own your intellectual property? Who might also have a claim to your intellectual property? Do you have any intellectual property dispute at the moment? And if you do, how investable are you? So even for those startups or mature companies that feel they have a solid case for capital raise, when the intellectual property due diligence question comes up, there's a rule of run over. What is your intellectual property strategy? How have you defended it? And how, when I invest in your company, can I be confident that you will retain the competitive advantage that gives you your purpose as a company? And that's a very delicate balance and difficult thing to get right, which means a lot of people are employed as lawyers dealing intellectual property. It's a complex area.
Yeah. Thank you. Marcus, you came all the way from Singapore.
Yes.
So I want to know what's your experience with the challenges and how did you solve these challenges?
So I think because Singapore is sort of a member state of the World Trade Organization and a lot of the international treaties apply, a lot of the types of challenges that we face are quite similar to what we face here, I would assume, and in the rest of the world as well. But I think the challenges, in particular in Singapore, as echoed previously, is mostly an incongruence and I dare say a slight complacency among our researchers because they think that, oh, I'm coming up with something really great and they're just really excited to get things off. And in Singapore, actually, there's a lot of quite strong government partnerships with the universities, with the startups. And the result of this is that they are very well supported in especially the IP side. Most universities have IP office, most research institutions have an IP office, and they work in tandem. So it sounds great in on the surface. But the truth is that because the IP office can be slightly understaffed, for example, then what happens is that there's also a lack of funds in filing patents, as our colleagues have mentioned previously, that once you file like a WIPO patent or international patent, you sort of have to file things into the national phases within 12 months. And you need to know the business, you sort of need to know the business and the territories you want to do business in. So the result is a lot of these researchers, they come across these IP and they face their IP officers and say, which country do you want to file in? And they're like, okay, we'll just choose the cheapest, whichever is the best. But that's not quite what your business or the technology you have will require, and it's not really the place that you want to file in even. So there are cases that I've heard, at least in the research centers in Singapore, that the researcher kind of let this drop the ball here. The IP lawyer didn't really, doesn't really know what the technology is about or what the opportunities are. And then both drop the ball, and in the end it's not investable because they don't have the patent right in, say, China, where we have, one of the biggest markets which Singapore is related to. So those are the main challenges, one of the biggest challenges that I see in Singapore.
Thank you. Yeah. I'll go to another point, which is the new digital area. How can we protect AI, artificial intelligence, blockchain, mobile apps, websites, probably? So I would like to hear from Khalid, please.
Thank you again, Lina. Actually, let me step back for the type of the IP. As mentioned by my colleagues, patent, trademarks, copyright, there is a very important type, the trade secret. Okay, it's a very important type of protection. Even big companies like Coca-Cola, now they are keeping their trade secret as a secret, because any other protection has a limit, patent for 20 years, copyright for 50 years. So the trade secret will go forever. There is no limit. So this is also one of the good types. Coming back to your question regarding the intellectual property and in the new digital area. So the general, this for example, for the artificial intelligence. There is two types for, if I talk about the AI, there is two types. One, the artificial intelligence itself, and the second type, the product or the invention created by the artificial intelligence. Okay, for the artificial intelligence itself, there is a regulation to protect, like generally like software or this even in US, there is protection for any computer applications or for any software. This can be protected under copyright. Okay, also can be protected again under the trade secret, because even the invention itself, you can divide it. No need, just even sometimes no need to apply one protection. If you can see in the invention, if there is part of the inventions it can't copy, not possible to copy, it's better to keep it also as a trade secret. Okay, and for the invention created by AI, there is a famous case of the selfie of there is one monkey in the, there is one monkey, it was, you remember, so the monkey took a selfie. So, and the photo is published and in the newspapers and now in this, who's the owner of the IP? Okay, there was a case in US, and the US, they decided the rights will not be offered to non-human. This is like one case. Also, this is one of the challenges because now who will own the right? There is a corporation or there is joint the responsibility, the software or the application itself or the robot or this. For till now, there is a lot of discussion, even internationally. I think in last December, in Germany, or they refuse. Yeah, they refuse to application generated by the AI. Yeah, it's so still there is a challenge and the discussion is still going on.
So if I may actually, just with regard to that artificial intelligence, we live in a very exciting time right now because the law is literally changing around us. The landscape of the law is actually evolving as we speak. Because as my colleague actually mentioned, so someone created an artificial intelligence, and that artificial intelligence came up with a solution to a technical problem, and they filed a patent application for it, right? And now the UK and the European Patent Office, they both refused it based on the inventor is not a natural person. They defined the inventor as a natural person. However, Canada and the US, they allowed it. Right? And they said an inventor is an inventor, no matter what if it's a natural person or otherwise, right? Now, this is actually going to create a new landscape of law altogether, because yes, we name, like for the US and Canada, for example, we name the inventor as the AI, but then who gets to negotiate the licensing agreement? Who gets to grant the licensing agreement? Is it the owner of the AI? Does the AI have the capability to actually grant such a thing, right? You know, I mean, does it have an understanding of what monetization is, right? It's just a machine that works for its servant, so to speak, right? So, you know, who really owns it? And these are all laws that are actually being developed. So, you know, is it a challenge? Absolutely. Do we have a solution? Not really, right? But it is something that we'd actually would engage the public forum in order to see. I'm pretty sure, actually, if we run through across this panel, we're not going to have a unanimous vote who owns the IP, right? in such a thing. So, I mean, even with a panel of experts, you don't actually have a consensus. Imagine what the public has to say about it, right? Yeah, and yes, there is an aspect of things, you know, I mean, again, touching on the trade secret, there's an aspect of things that can be held as a trade secret, but the trade secret is only good as long as it's maintained secret. That's why Coca-Cola has actually better security than the securities that protect nuclear launch codes. Because you walk away with that formula, Coca-Cola basically would go from $1 billion, you know, worth $1 billion to zero overnight. So is it worth going for a patent protection, for example, or a design protection or anything that is a time limit, but at the same time, it actually grants you a right? So, I mean, something to just circle back about one thing that was actually mentioned, you know, what is the right? It's described in the law as a negative right, which is the right to exclude others from making, using, or selling. Right? In some jurisdictions, such as the UAE, it is also a positive right. So not only do you prevent others from using, you are actually allowed yourself to use it, right? Which, you know, I mean, it's implied, but it is actually enunciated in the law itself, right? So.
Thank you, Rami. So, Ahmed, I would like to know, you know, these regulations are not applicable in the UAE to protect the coding and the softwares, although it's there in Canada, as Rami said, and US. Do you think we need to change our regulations here in the MENA region, GCC, UAE, Patent Office?
Certainly, what Rami and Khalid they described with respect to the ownership of inventions related to artificial intelligence. Whether machines in itself can be considered as inventors, yes or no. Now, this is, of course, a big legal debate, and we can, you know, have a huge debate about that. And countries also, they are debating that because not only it involves law, but it involves more public order and public policy, and it has many implications and repercussions on the society and so on. Now, the other side is the protection of AI systems in itself. What artificial intelligence in itself as a word is used today as a buzzword. Okay, so it's misused, a lot misused. Artificial intelligence, AI, AI, AI. AI, at the end of the day, it is, you know, when we say AI, there are different types, but it's, at the end of the day, it's a way of coding or a way of generating codes, and the way of solving problems using code and using machine learning to take examples and then to feed it to the machine, to have the machine learn from these examples and come up with outcome. It's coding at the end of the day. It's a software at the end of the day. So yes, there are some new realities today, some new legal realities, but in a big part, the legal realities which existed before are also existing today. You know, AI has been there for 50 years, okay? But the way today, why we're hearing much more AI today, it's because it got enabled because of the advancement of computing systems, of the memory chips, much more capable, the speed, the internet speed, we're talking about 5G. So all these computing capabilities will make AI much more performant. So that's why we're hearing it more. But AI has been there for the last 5 years and 50 years and passed through different phases. So the legal realities when it comes to patentability in a big part has been there. Today, yes, there is maybe a part, a small part, which is a new reality. Now, when we speak about the regulations of the United Arab Emirates, and we compare it to what's out there in the US, in Singapore, in Canada, and so on. Certainly, in the US or in Canada, you can find, it's a different legal system, first of all. The legal system in the US is a common law-based system. It's based on precedents, it's based on decisions, on court decisions, on the laws are much more detailed and so on. And the experience in terms of patentability of these kind of systems, we go back to the 80s and 90s where the big American companies, eBay, Amazon, Google, and so on, they've created a certain legal reality or a certain reality, okay, technical reality, which the patent office and the courts had to deal with at that time, okay? And so a legal system has been created there, and it's very detailed and it's very heavy one. And then, so the regulations there are really very intense and very present in terms of what is patentable and what is not patentable. And still, with all of this, and the number of patent applications filed, you're speaking about 700,000 to 1 million patent applications filed every year in the US. So with all of this, of course, the regulations are much heavier and more intense. Okay, and even with all this, still we have gray zones today in the United States when it comes to the patentability requirements of computer implemented inventions and so on. So now when it comes to the UAE, of course, we don't have that level of regulation and even of examination guidelines when it comes to the patent office, okay? So we file a patent application today, for example, related to, AI related, for example, intelligence system for autonomous cars, let's say, okay, for navigating autonomous cars. All right, so now how it is examined, okay, there are no detailed examination guidelines in order to help the examiners to examine that patent application, or decisions and with internal database to help them, to guide them, and so on, to build on that. And most of the examination when it comes to these type of things would be most, based on the discussion of the examiner, based, on certain influence maybe by some patent offices here and there. Yes, we need a higher level of regulation. But again, I discourage to go and copy other systems, laws, and regulations, okay? UAE has a certain reality today. It's different from the US reality. It's different from the European reality. It's not about law only. It's about, from the economic perspective and the public order perspective, what do we want to achieve? Do you want the UAE to be a hub for artificial intelligence? Do you want to attract these types of enterprises and investments inside the UAE? Now, how can the law help us to achieve that? And from there, we go and we regulate. Okay? And not the opposite, not because the US has very high regulations today about the patentability of these types of inventions that we need to copy it. And again, even the US is highly political. At the time of when the head of the USPTO was pro-Google, the regulations with respect to the patentability of computer-implemented inventions and e-commerce was different when the USPTO head has changed the last year. And that's when we started to see more appetite to accept these types of inventions. So it's also political, it's economic, it's public policies, and this is where we need to look at in the UAE and then come up with some laws and regulations which help us as an economy and society to go to the next level.
Thank you, Ahmed. I'd like to ask Jamie, how can academia, industry, and government agencies improve their collaboration in order to make Abu Dhabi and overall UAE more competitive with regard IP protection?
Look, I think that comes down to a healthy discussion among the parties you just mentioned, close cooperation and understanding what drives each party so that each party wins out of collaborating. Universities have a very specific mandate and they want to attract best-in-class academia and professors to fill the university with high-quality students and winning programs. You know, industry wants to collaborate with sectors and centres of excellence that have the resources and the people around them to help them advance. Capital is required and capital partners are required to help underpin that which is not yet commercial and through solid programs like ADIO's rebate, subsidy and grant programs. So I think collaboration is very important in a true sense. I think you'll find when we look at the free zones in Abu Dhabi, you see a set of rules and regulations that encourage entrepreneurialism and innovation. If you look at the ADGM, you see ADGM law, import English law, which has the history in relation to intellectual property cases that are now part of that landscape. And so when talking with foreign parties about ADGM law and the ADGM, people getting very comfortable with its history and the attachment of English law to the ADGM law. So it's about, I think, bringing those things together and us as a United Arab Emirates as well, determining which areas do we want to focus limited resources on. There are a limited number of universities capable of in the country. Every country has a limited number, but which universities should apply themselves to what area, with which international players, with what kind of capital programs. It's not easy to come up with the answer to that, and I think part of that results in some trial and error. So if you look at some of the programs announced by ADIO, EdTech, Biotech, Agri-Tech, these are areas where we see a huge future for the Emirate to become a winner. And I think it's that determination, that strategic direction that is then required to ask universities to collaborate, industry to collaborate and provide the financial incentives and resources to then march to one goal. Very difficult to do, but the conversation I think is well underway with free zones, with universities, with government departments, government entities, players like ADIO being involved to make this happen for Abu Dhabi.
If I may add, because I come from Singapore's perspective, and my country is very well known to just mobilize every sector of our country to be a hub for things. So I completely agree with whatever has been said, but I think also rather than as everyone has pointed out, we don't look at silos. We can look at academia, we can look at all these, but actually it's really a whole society, a whole attitude to society, to how the society sees something. So at least in Singapore, there is a very strong drive for everyone to focus on data analytics and artificial intelligence. So they actually created, in our country, we created an institution called AI Singapore, where it is just AI experts, and they work with industry, and they try to find AI projects. So there are like a few thousand applicants for this internship program that they have there. You can be at any level, but only apparently 3% get in. They are trained in AI, and then they go into the industries. Also in Singapore, in terms of the IP front, the Singapore government had, the Intellectual Property Office of Singapore has decided that in artificial intelligence patents, they will process it within 6 months. So you would be able to get the patent within 6 months from the time of application within Singapore. So it will not remove the problem of having to file your patent in every single jurisdiction, of course. But the thing is that when you have a patent in Singapore, you can say, oh, it's patentable in Singapore, let me go to investors. There's a lot of certainty, and you can even tell other patent officers, oh, I got the patent in Singapore. So it becomes very attractive and it addresses real pain points of these startups and these companies that want to patent AI and do AI. So I say humbly, of course, I don't know the situation in UAE, but I think as a general principle, if we want to improve anything in any sector, we have to target the pain points that the businesses and the scientists are facing when they are looking at these issues.
Yeah, it's a matter of adding legitimacy.
Yes.
Right? So when you're getting a patent under your belt, you basically approach an investor and you say, it's not just a working idea. It's not, I filed for it, but I have no idea if I'm going to get granted or not. If once you actually have a granted patent, that's legitimacy. That's basically telling them an examiner has looked at it, he examined it, and he's okay. Like, he looked at other possible references, at other possible similarities, and he found distinction. Right? So, but then one thing actually I just want to touch on, sorry for, for jumping in right here. Artificial intelligence, as Ahmad said, it is a buzzword, but it really has evolved over time as well. It's not like a static definition. When the computers were first created, that was, some people thought that was artificial intelligence. It's a machine that can think faster than a human. Once supercomputer got generated or got created, then it's a machine that can really think faster than human, right? And then once we created networking between computers, that became the new artificial intelligence. In my definition, actually, it's a machine that can think for itself. It's not something that you can program in order to do it much faster than a human. So at the analogy that Ahmed said, for example, artificial intelligence was thought to be something that can learn from permutations. You give it a whole bunch of scenarios, it will learn, it will actually achieve the best one. But that's more of like, from a programming language, that's sort of like a trial and error, right? The way actually true artificial intelligence is a machine that can think for itself rather than learn from mistakes.
We are not there. I disagree with that, sorry. We are not there at a machine thinking by itself
That's
today.
actually
and this is a big debate, and I would love to have this debate.
Yeah.
But to have a machine thinking today by itself, we're really not there.
It's been created actually in the US, a machine that was given only instructions of how a chess game runs, and it won its first game.
Well, the Western system, it's very debatable. It's not I don't believe it's thinking about itself. This is where the big debate, as you see, comes from, as whether a machine should be treated as an inventor or shouldn't be treated as an inventor. And here, it's a debate that I can have with Rami, or we are here 100 persons or 50 persons in the room, and if we have this debate, everyone would have a different opinion. But this is today the debate going on, whether a machine can really think about itself, or it's taking the instructions from the programmers and using examples to learn about from these examples. And today, for example, you look at Google. Okay, Google today, they worked on their AI system for years and years, and to feed up the system to be able to recognize a cat from a dog. And until today, it has mistakes of recognizing if this is really a cat or not a cat. Okay, and it read millions and millions of examples. Alexa from Amazon, and the same thing. You speak to the machine, okay, if you go a little bit outside of the line, it will tell you, excuse me, I don't understand what you're saying. So today, this is the debate. Is a machine today can think or can be able to think down the road, even in 10 years, 20 years, by itself, yes or no? My opinion, and I give this opinion openly everywhere, is that a machine will always run after creativity and after to be able to obtain it, but it will never be able to be creative and to think by itself. This is my own opinion. And I went to MIT. I did one whole year about innovation and artificial intelligence to find out about this question. to know whether a machine can think or will be able to think, okay, by itself, yes or no, and this is my opinion.
Thank you, Ahmed. Khalid, yes, you want to add?
Just I want to add one point. Yes, here in the UAE, we really have capabilities to apply the best practice. Okay, what we need, from my point of view, we need two things. First of things, the awareness of the field itself, for the professionals, for the stakeholders. Previously, intellectual property was only held by, for example, the legal department. And even they sending to the marketing, and marketing sending to the sales, and like this. Now, intellectual property should be in line with the all industry, with the legal, with the sales, with the marketing, in line with the strategy, whole strategy of the company itself. The awareness for the academia, for establishing their IP units, their IP departments, their technology transfer department, for all sectors of industry, to establish their specialist intellectual property department. And the other point, the discussion between all the stakeholders, between the entities, between the government, between the IP lawyers, between the inventors, between all, like a public discussions. Now we have a problem, okay? We don't want to apply, as my colleague Ahmed says, that the same experience of the US. But one of the challenges, the nature of the intellectual property itself, the territoriality nature of itself, okay? And here, if we want to attract the investors, we need to make a solid IP, solid protection. Without IP protection for all fields, and here in UAE now, we already have a Ministry of AI. That means this is our line. So we have, I think we have to open discussions with all the stakeholders in the field, and we have the capabilities to apply the best practice, whatever is it.
Thank you, Khalid. I'll just go back to Faisal with the same question regarding how to improve the IP protection, the collaboration to, wait, I'll just repeat the question. Okay. How can academia, industry, and government agencies improve their collaboration in order to make Abu Dhabi and overall UAE more competitive with regard IP protection?
Personally, I believe Abu Dhabi could have in the future a good tool be a good destination for attracting inventors and IP. The collaboration is necessary between university, because the university is one of the key players in the IP system, government on other side, and also investor on third side. Collaborations need to be understood, and maybe in the future it will require creating a platform, bringing all these parties together, understanding the gap in the system, discussing maybe the future regulations, understanding what is the opportunity. We hear a lot of speech about AI, and maybe there are a future regulation will be necessary to adopt the AI machine learning here and improve our economy and industry. Maybe during this discussion between all these parties, they could identify some gap in the cost, because we need to attract more IP here. Maybe the cost of registration is high. Maybe some gap in creating incentive law in the area of university, incentivize inventor who will invent something. So the law could also help creating a new law for the industry, incentivize them to invest more in the R&D. This could be opportunity here in Abu Dhabi. I believe the collaboration is important, creating a platform between all of them to understand the gap, understanding the opportunity will be useful. If you can see, US they are spending a huge, as a government, they spend a lot of money in the area of research and development, around $500 billion every year. And this is reflecting the IB system there because they invest a lot of money. Parallel, they build a strong IB system around it. And you will see the same example in different destinations. Here in Abu Dhabi today, Abu Dhabi Investment Office, different party is investing a lot in the area of innovation. We are seeing a new entity established in the area of R&D. We believe in the future, Abu Dhabi will be one of the driver of attracting IBs here in Abu Dhabi. I work in this area a long time, and I believe we will see a lot in the future here in Abu Dhabi.
Thank you, gentlemen. I worked with you in the last 5 years, and it was so fun. Thank you very much. And yeah, if you have any questions from the audience. Yes.
My name is Amna Shamri. I am a founder of Innovation Gate, which is it is a platform that acts as an intermediate between inventors and investors. My question is, when I ask the student or any people to upload their inventions, they effort actually, because they said, what if we upload the idea and it is not, or anyone can steal it? Let me give you, first of all, a summary about the Innovation Gate. Innovation Gate has, as mentioned earlier...
Don't disclose, please.
Huh?
Don't disclose your invention.
Yeah.
Who's speaking?
Yeah.
Okay.
Yeah, still keep. Yeah.
Anyway.
This is one of the important things. Go ahead, please.
Okay. Investors can upload their challenges to the platform, okay? And inventors can check the challenges, and then they can find the solutions. Okay, now inventors or any visitors for the platform cannot, or they are afraid to submit their ideas. How can I encourage them to upload their ideas in the platform?
I can take
Although
that one.
terms and conditions, terms and conditions will be mentioned in the platforms. Terms and conditions saying that whatever ideas is submitted to the platform will be owned to us and will not be disclosed to anyone instead of any parties instead of Innovation Gate, which is us. So this is the question.
We
Can
will
I-
not respond to this. You need to pay us money to respond.
Well,
That's why we are here, and that's why you are here as well.
No, I was going to
get an
start by
advantage.
anything I say, as a disclaimer, anything I say is not legal advice and is considered only for educational purposes.
Come
Right,
on.
so- No, but I mean, you definitely have the right idea, which is to make sure that any information shared is confidential. Because as my colleague said, once they basically announce it to the world through uploading it to a form that is even assumed to be public but not perceived to be public, that is a loss of a specific criteria in order to actually get patentability in many countries of the world, right? So I mean, part of it goes into a little bit of what I discussed earlier, IP awareness, right? So I mean, maybe part of your platform, I appreciate that it is it's a vehicle to connect between investors and entrepreneurs and inventors, but maybe an IP branch should be also there, right? So, I mean, because investors are interested in legitimate ideas, these are like unique, workable, inventive solutions to a technical problem.
And how can I connect you to
Right,
my
so,
platform?
well, talk to us, as Ahmed said. So, I mean, the whole idea is trying to actually establish also a portal where inventors can communicate with patent attorneys, where they can communicate with IP lawyers in general, in order to identify what their assets are and what can be protected, and then take that to the investors. I think that would be actually a workable ecosystem where there is beneficiaries on all sides of
So
of the
you
table.
mean whoever submit their idea will be protected first and then shared with the parties,
Mr.
right?
Shamiri, your platform, okay, I'll give you my opinion on that very quickly. You need to sit down really with you need to sit down with the legal advisor, and you need to put a strategy around that. We cannot give you now here, okay, a full advice on that.
Yeah, I
because
understand.
there are many aspects to that, okay? And it depends on the type of information. It depends on the status, on the level. What is this type of information the inventors are coming up with? Is it initial ideas, or is it something conceived? Is it a product? Is it something which is, there's already IP around it? Is something protectable? And now, to solve these problems, there are different options to serve these problems. Maybe the information you're conveying between this party and this party is still within a confidential channel, and maybe contractually you can bind the parties. I don't know, but what I'm trying to say is that there are so many elements around your project that you really need to sit down with a legal advisor and look at it from all aspects around. But your reflexes are the right reflexes. If you take information, okay, and you put it on the platform and it's open publicly, if that information is disclosing confidential, technical, inventive information, it is public disclosure and you kill the novelty. They can't protect it through patents. But if what you're conveying is marketing information, just top level, that's not at the public disclosure. So what type of information you're conveying? So there are a lot of elements around it, but you have the right reflexes, yes, but you need to sit down with a legal advisor to put a strategy around it.
If I may as well, I think that that you can talk to anyone and people can give you a legal perspective, but you have to look at the case perspective, the business case perspective, because at the end of the day, if I'm an inventor, I've put most of my life, well, not most of my life work, but many years in coming up with something like this. Why would I just put it out there and suddenly like just tell, and basically I don't think the inventors would even be aware of IP law, but they have this great disdain and they have this idea that once I put it out there, I will not be able to protect it. Yeah, so that may be something you need to talk to the inventors themselves before you...
Okay, but there's a lot of competitions which ask the inventors to upload their inventions, right? So they are also spreading their inventions as well in this.
Yeah, unfortunately, a lot of these competitions lead in sad stories, which is you get your 15 minutes of fame, and then everybody else copies that idea. That's what Ahmed was talking about. Like, you really need, you know, I mean, the rule of thumb is always file first, disclose later, right? So, you know, maybe some of those entities that actually upload their inventions or upload their solutions on a public platform have actually sought that protection. So they filed it. So they're fine to actually upload it. You know, they're not losing anything by doing that. And that's what, you know, I mean, connecting the inventor with the IP branch, with the IP aspect of things, would actually give them more comfort in order to participate in your platform.
Okay, but there's in any way they have to upload their ideas, and after that there's like second party and then third party, which is the investors.
Right.
Okay, thank you very much for your time, and it's take too long. I think, yeah, I need to speak to a consultant maybe. I'll take her business card if you don't mind.
Absolutely.
Hi, my name is Amar Al-Dakak. I just have a comment. So basically for IB laws, I think it's not the main focus for us, because sometimes in some countries there even no examination at all, like South Africa. We don't have examination there. So the IB laws are really supposed to serve the economy. It's not supposed to be political even. In the US, it's court decisions that come out that explain the law from the perspective of the court, and then the patent office is just responding to that. But I think the challenges that we really have in the region here is the examination. Do we have really good examination procedures that going on that is clear to everyone, and we can expect when our patent application can be examined and finished or not? So that's the first thing. Then the enforcement. if I'm an investor and I'm putting a lot of money to get a patent application here and get a patent, do I really trust that it will be enforced after that? Or I have to hustle through the system to get this patent enforced and nobody else can copycat what I'm doing? And third, I think the course itself, are the course ready here to look and decide on invention? They have the technical background for it or not? So I believe these challenges, from my humble opinion, are more important than the IB laws themselves, because it's really, by the end of the day, as the panel said, it's how the UAE or the GCC region looks about how they want to protect and to attract investors. And if you really look at the patent law around the world, most of the issues everybody in harmony with. It's kind of very little changes. I would say 10% or 15% are major differences between all the patent laws across the board. So I believe that, yes, IB laws are very important, but the most important is the legitimacy, as the panel said, about if I have a patent, can I enforce it? If I get into infringement or I have an infringement of my stuff, can I really have my rights protected or not? I think that's where we should put some value and weight on.
Yeah, and just to add to that comment, actually, so the idea of the UAE is a junior country when it comes to patent protection, right? That's no secret. But this, to me, actually is, I'm an optimist, so I see this as a way actually to advance faster than anybody else, because we are surrounded by countries and jurisdictions that have sophisticated legal system. And yes, we don't want to copy something blindly, but we can learn from it. We can extract things that actually work within this jurisdiction for the purpose that we want to adapt it to. So for example, like Ahmad said, like if we really want to, make the UAE as a platform for AI or for any type of innovation or for innovation altogether, right? I mean, as a hub for all innovation, then we want to actually have a support system, be it as it may, awareness to the public, to the government, as well as laws, as well as costs, of course. I mean, cost is a major thing for all investors that actually want to invest in the UAE. Is it cost prohibitive, right? Can I actually maintain this filing? Is it worth doing it? Or do I want to just basically exploit the market until someone kicks me out of it, right? So all of these are legitimate questions, and all of them really depend on the mentality of the person and the government. So it is actually a conversation that needs to happen.
Just to add one thing, software maybe is one of the very hot areas today. And if we look at South Korea today, South Korea is known to be one of maybe the most important high-tech development countries in the world, and Japan as well. If we look at the laws in South Korea and Japan, and we compare it to Europe, for example, with respect to software protection in patents, we'll see a huge difference in terms of laws, where these South Korea and Japan are extremely pro patentability, and you go to Europe is the other extreme around. So yes, we need to learn, we need to look at these systems, we need to learn how these laws have impacted the development of industries there, and try to look in the UAE, what do we want to achieve in terms of economy, in terms of boosting industries, certain industries, which industry we want to focus on, and then try to learn from these to come up with our, and as Rami said, I totally agree. When there is over-regulation, sometimes it's not something which is highly positive, because it's rigid, your area of maneuver is low, and because now we are under-regulated, maybe it's an opportunity to come up with the right regulation to go for the next step forward.
And that would also shoot up to enforcement, because right now, because the patent system is junior, everyone is interested in filing. Everyone is interested, like, that's really it. It's not even actually getting a grant, because it takes a long time. So part of the solution is maybe trying to expedite the prosecution process in order to get a grant going. But from it, when it comes to enforcement, you have to have a grant in order to enforce that legal right, right? And with that, so once you have that legal right, you have to have proper education to the courts, exactly, to the judges, in order to actually make the right ruling, to understand it. So right now, the system is in flux because the courts depend on an expert witness. But then who decides that being the expert, right? So.
We have a question from
Yes, thank you very much. You can see we also have award for innovation. What I notice in university that students like to come with a lot of ideas, but when they see the long process of application and to get patent, they get kind of discouraged because they want to finish their degree and get a job. Okay, as Marcus mentioned that in Singapore there's a fast track 6-month application. Could we have in UAE such so the student feel like they own something and they are appreciated?
That's a great idea.
This is something that we've been pushing. Faisal excites everyone around.
I think the inventor, he needs to spend time to disclose his idea, and he needs to put effort to disclose his inventions, because if he enter in filing a patent, if it is fast track or long track, he needs to disclose it. The difference between fast track and long track is spending more money. If you want to spend more money, you can go with the fast track. So the challenge what you are highlighted is the disclosure of the technology, disclosure, because you need to engage with the patent attorney. The patent attorney will enter in detail. He needs to understand what is the claim, what is the novelty, what is the utility, what is the claim. He should put it inside the patent. And the inventor, he needs to spend time, really, to disclose this idea with the patent attorney. And this is the value of his inventions. If he do it fast, and he disclosed something very high level, he could maybe in the fast track or longer track, he will not have any inventions.
Yeah, what we have experienced that after submission of application, student wait for interview, and then there's couple of interview and discussion. Is it possible to send an attorney to the university on in interval basis? If, for example, if university have a 5 or 10 application, attorney just go there and discuss with the one-to-one. So just to speed up the process, not to wait 1 month and 2 weeks or 3 weeks for a response. Just to
every university, they have a technology office, and they need to put this as a priorities. So their priorities in any university, they try to rank them high ranking, and the ranking is coming from the publications and from the inventions and patent. And the first thing, university, from strategic aspect, they need to see this as a priority. Based on this, their leadership.